Good morning, everyone. I want to make sure that everyone can hear me okay first. Can someone just respond in the chat? Let me know that you can hear my audio. Thank you. I have a thumbs up. Perfect. Okay, so I'm going to go ahead and go through the presentation. I'm going to ask that you please hold off on questions while I'm going through the presentation, but feel free to go ahead and drop them in the chat. And then at the end, I'll go ahead and review and address, and then we can do also some live Q&A. Okay, so first off, I just want to say thank you to everyone who is joining us this morning. My name is Leah Schoen, and I'm an associate at the Green Law Group. Before moving over to the Green Law Group, I worked for a large insurance company for 10 years, starting as a compliance officer. And then before I left, I was in-house counsel. So this presentation today is what contractors need to know about insurance. It's presented by Scott Green and myself, but I will be the one speaking today. Also want to take an opportunity to say thank you to our sponsors, Easy Law Construction Notices, Ventura County Credit Union, BCCA, of course, Builder's Book, and Blue Book. It wouldn't be a legal presentation without a warning. So fair warning, information contained in this presentation is not legal advice. The law changes constantly with new statutes and court rulings. So for legal advice regarding California law and the facts of your particular case, we request that you consult with an attorney who has substantial experience in your area of concern, which, obviously can feel free to reach out to our office. Okay, a little bit about the Green Law Group. Our law practice was originally formed to serve construction professionals with contracts, licensing, and notices. As our clients' legal needs have grown, our law firm has expanded to meet that challenge. And today we offer a full range of services to help small businesses thrive. Our clients rely on us to make sure they're organized, their legal documents are in good order, compliant, their employees are paid correctly, exposure is limited. And so that our goal is when our clients do go to court, we're right there at their side, working to make sure they have the best chance for success. Here is the Green Law Group attorneys, Scott, Mike, Matt, Simran, Kirk, myself, and Bradley. Okay, so let's start on the conversation in regards to insurance. Specifically, we're going to talk about commercial general liability policies. Two main issues that I see time and time again are clients who contractors who come forward and say, I have a legal problem. I asked for a copy of their policy. Either they don't have a full copy of their policy, and it's usually just like a few endorsement pages or certificate. I want to just preface this by saying, if you have a policy or what you believe to be a policy and it's less than 30 pages, it's not the full policy. You're entitled to a copy of your full policy every year. You should request it if you don't have it. You will get it at the time you bind, but some people have had the same policy and they're just renewing over the course of many years. And so you just get the exclusions and endorsement pages every year of what they are giving and taking away, or more taking away, and not the full policy. So please, please, please make sure you have a full copy of your policy, because I am going to ask for it. So the two main issues I see outside of that one particular preface issue is contractors buying the wrong insurance for their business needs, which we're going to discuss today. And also contractors, agents, and brokers, and even attorneys not fully understanding how to properly tender a defense to an insurance company. Okay, so I feel like, sorry, I think I'm missing. Nope, okay. Apologize about that. Okay, so commercial general liability policies. So there are different kinds of policies, but the most common one, and the one we're going to be discussing, is CGL policies. But you should be aware that there are other kinds. More predominant now are wrap-up policies, or known as wraps. There's OSIPs, which are owner-controlled insurance programs that are purchased by a GC to cover liability. on a construction project across, well, it's by the property owner. And then a contractor controlled insurance program is more to cover liability on a construction project over the course of multiple projects or ongoing projects. But we're going to be focusing on commercial general liability policies, which is the most prevalent, the one that I see most often, and the one that every contractor should have. So we're going to be talking about, what it covers, and exclusions. And I don't think, I'm sorry, I'm going to pause for 1 second because I think this might be incorrect. 1 second. Okay, can everyone see my screen again? It should be back at the first slide. Can you just someone put it in the chat or thumbs up would be perfect. Okay, great, thank you. I spent all this time on it and then didn't even put the most recent one in there. Here we go, perfect. Okay, so back to what I was saying. CGL policy is a type of insurance policy, provides coverage to a business for bodily injury, personal injury, property damage. It is not for you as a contractor. It is really to protect your business in the event that there's injury or damage to others or others' property. And it's obviously has to be arising out of the contractor's business operations. And what I was discussing previously was the wrap-up policies, owner-controlled insurance programs, contractor-controlled insurance programs. But we're going to be focusing on commercial general liability. Okay, so there is 5 basic elements to a CGL policy. I always find it's helpful to sort of know the universe macro level and then focusing inward. And so that's why I wanted to give you, the sort of the elements side of what is the CGL policy. So you're going to have first the insuring agreement, which is going to tell us what's covered. So this is part of the agreement where they basically say we're going to pay, or we agree to pay in certain situations. But that payment is triggered, has to be triggered by an obligation of an event, right? So there needs to be an event that triggers for the insurance company to pay. If there is no occurrence or event, then the insurance company is under no obligation to pay. And we'll discuss, what an occurrence is in a little bit. The second part is exclusions. So they giveth and then they taketh away, right? So the insuring agreement is everything they're going to cover, and then they sort of start to nitpick at that policy. Exclusions are going to tell us what's not covered. And then there's going to be exceptions to exclusions, which are items excluded, but that are covered, right? So it is confusing by design, but we'll sort of discuss that. Exclusions limit the insuring agreement, and by removing certain things that the insurance company is under obligation to pay, what is often considered outside the scope of the insuring agreement. So, for example, bodily injury or property damage, exposures outside of what the insurance policy intends to cover. All CGL policyholders may have to show is bodily injury or property damage caused by an occurrence during the policy period. And then the insurance company uses exclusions to limit that exposure to only those specific instances where the insurance company has an obligation to pay. Exceptions to exclusions tell us specific items that are removed from exclusions. So removed from exclusions, not removed from the insuring agreement, thereby making them covered. An exception removes the conduct from the exclusion. And since the conduct has been removed, it's not excluded. I know it's very confusing and frustrating, but this is how it's crafted. The next part is conditions. And so those are really the parameters, boundaries, limitations on coverage. The impact of conditions on coverage can be severe. The insurance company may require notice of an occurrence within a reasonable time after the policyholder learns about the occurrence. The intent of the insurance company at that point is to make sure that they can defend their insured effectively according to the terms of the policy. They can't do that if the claim isn't submitted or they're not put on notice for 3 or 4 or 5 months after the fact. If the policyholder waits too long before informing the insurance company may be limited in their ability to defend And there may also be limitations on what they're willing to cover. To ensure the insurance company receives timely notice, they will require timely notice as a condition of coverage. They all have that in their policy. So you should be aware of that. You should check for it and you should report timely. If the insured fails to provide timely notice, it prevents the insurance company from defending. We talked about that, and it also could deny payment to the policyholder. The last one, and arguably the most boring, but I think it is one of the most important parts, is definitions. How terms in the policy are defined. It's too often ignored, and it can have a huge impact on coverage. One of the things I do want to draw attention to is that terms that are in quotation marks in your policy are not used for irony or emphasis, okay? Those are used in an insurance policy to designate that the word or words within the quotation marks are defined elsewhere in the policy. So if you're reading up your policy and there's terms in there that have quotation marks, you should be referencing back to what exactly is the definition for that term. The definition section's often at the end of the policy. So, it's counterintuitive. It should be at the front, arguably, but it's in the back. And unless you're someone who enjoys reading something like the dictionary, it may not seem very interesting. And you may think it's not, you shouldn't have to read it, or you don't want to read it, but I'm emphasizing that it is important. And here's an example. Coverage B provides coverage for personal and advertising injury. You may read personal and advertising injury and feel that that's all kinds of coverage for any lawsuits involving personal or advertising injury. And that may be very reasonable, a reasonable interpretation. And it's in quotation marks, okay? So that means it's specifically defined. So when you go and look at the personal and advertising injury definition, it says it's defined as 7 specific personal and advertising injury offenses. So if the offense is not one of those 7, then it's not classified as personal and advertising injury, and therefore it's not covered under coverage B. So those are the 5 basic elements I want us to keep in mind as we sort of work through the CGL policy. The other thing I do also want to just make sure you're aware of is there are different kinds of policy formats. There's an occurrence form, manifestation, and claims made. The most predominant is occurrence. So largely it's triggering, when coverage commences as it pertains to the occurrence. So occurrence form is the most prevalent, and that's the one we're going to focus on. And just to further clarify, it's designed to cover occurrences that take place during the policy period, nothing outside of the policy period. Okay, so in every CGL policy, there are 3 coverage sections. There's coverage A, covered unless excluded, B, personal and advertising injury, and C, medical payments. The one that is the most pertinent for purposes of liability and what I see and what the issues of coverage are is going to fall under most of the time under A. So that's what we're going to focus on. So again, what it covers is occurrences. The ISO, which is the standardized insurance form that most carriers use, defines an occurrence as an accident, including continuous or repeated exposure to substantially the same general harmful conditions. All are going to require bodily injury or property damage caused by the occurrence. So, just sort of cliff note version, accidental bodily injury, accidental consequential damages, more likely than not, is going to fall under an occurrence or event. I want to say also that if it's not accidental, so if the damage was the result of an intentional act, it was not an accident, and therefore it's not going to meet the definition of an occurrence. Intentional acts are not going to be covered. It's just not. This position favors insurance companies, makes it difficult for a policyholder to find coverage for a construction defect if because the act of construction itself is an intentional act. So I know that sounds very counterintuitive, but these are sort of the workarounds that we find when we tender claims, and you have to navigate it. If the damage is the unintended result of faulty workmanship, it's an occurrence. If damage to property other than to contractors' work, it's an occurrence. So exclusions, why do they matter? What are they? So the Standard Insurance Services Office CGL policy, the one with the 3 coverage sections, will include 17 standard exclusions labeled A through Q. Now, it's possible there could be more. There could also be, endorsements and exclusions added on, at the back end of it. But most of them have 17 standard exclusions. I'm going to focus on the ones that we see the most and are the most applicable. And those are going to be what I call beware of JKL, right? So you've damage to property, damage to your product, and damage to your work. These are the exclusions that are always, I'm seeing time and time again at issue in construction cases. So there's the your work exclusion, and then there's completed operations, and I'm going to go through some examples. Even if a policyholder is able to prove that the construction defect was an occurrence triggering coverage, the insurance company is going to have an opportunity to prove that coverage should be denied because of an applicable exclusion. So you should know that. And like I said, these are the most commonly cited exclusions for construction defect purposes. Okay, so let's talk about your work exclusion. So here's we have a case study example of a roofer. Okay, so while installing a roof, workers puncture a hole when finishing the job. The roof leaks, causing internal damage to the water. There's internal water damage to the drywall in the interior. Owner sues the roofer. Question is, will insurance, a standard CGL policy, cover repairing the hole in the roof? No, they're not going to, because that was what you were contracted to do. That's within the scope of work that you were to perform, and therefore it is your work and is going to fall under a your work exclusion. You were paid to do this, and so the fact that it was done incorrectly or is faulty workmanship is not going to be covered. Now, will the insurance company cover the drywall, the damage, the what's considered resultant damage, or the result of the faulty workmanship? Yes. That is largely what the CGL policy is for. Again, it's not for the contractor, it's to protect these other third parties that experience damages or injury as a result of the work. And so just as a reminder, exclusions are limiting the insuring agreement by removing certain things that are outside of the scope. And so an exception will remove the conduct from the exclusion, but otherwise the exclusion is just removing it from coverage. Okay, so then the next one I have is a mason, completed operations exclusion. This one doesn't come up as much, but when it does, it can be fatal. So the policy in this scenario, hypothetical, if the policy being offered is half the normal price because it has a completed operations exclusion, a masonry company believes that its major risk of loss takes place while it's building a wall and not after wall's completed. So the company purchases a policy, appreciates the savings. But now imagine after wall's completed, it falls on a row of cars in a parking lot. The car owners all sue the masonry company. Is there going to be coverage? No, because it was completed. And the insurance contract will clearly state, if there is a completed operations exclusion, that it precludes completed operations. So please be wary. That's one of those things where you just have to read the policy. And so why has this come up? Because contractors will buy the wrong insurance, unfortunately. There's communication breakdowns between the contractor, the insurance agent, and the broker. They avoid buying a policy with exclusion. You should avoid buying a policy with exclusions that's going to eliminate most coverage for the type of construction you're performing. So for example, we'll see, there's an earth drilling contractor who sold a policy and there's an earth movement exclusion. That is never going to serve the contractor for purposes of protection on liability in their business. They're engaging in, a scope of work that is specifically excluded under their policy. Another example is contractor's policy excludes new construction. But the contractor does occasionally do ground up construction. You're not going to have coverage. For any contractor has an exclusion for a residential remodel of framing, again, going to be excluded. So remember, if it's not excluded, it's covered. And I do want to emphasize that because, sometimes the question is, well, show me in the policy where it says that. Really what you're looking at is, does it say that it's excluded, not does it say that it's covered? Because remember, it's considered covered absent an exclusion. And then if it is in an exclusion, is there an exception to that exclusion? So what to look for in an insurance policy, you're going to look at the scope of work or description of the work clause. Policies that exclude your type of work is going to be an issue. Make sure that the insurance application you're submitting is very accurate. And I would even go so far as to draw attention to the fact that this is my scope of work, so I want to make sure I have adequate coverage. If descriptions are unclear, incomplete, or inconsistent, you're going to run the risk of not having adequate coverage. Another example I want to provide as a case study is something that you wouldn't necessarily assume would be part of the work and therefore would need to be on the policy, but you could run the risk. So I'll give you an example. Another case study of a plumber. The scope of work matters. He's hired to install a new toilet in a house. The toilet is installed with all the necessary venting, right? There's a fan, there's a vent in that room. It rains. Homeowner complains that water's leaking through the roof near where the plumber installed the toilet vent. The plumber tenders the claim to his or her insurance company, but then receives a denial based on a roofing operations exclusion. Now, that plumber probably went in and said, oh, okay, as long as anything plumbing related is covered, I should be good. Not thinking that the vent is not going to be covered, even though it may be within the scope of the work that's being performed. So I just want you to be aware, really sit there and think about what is the most expansive definition of scope of work, and do I have proper coverage for that full scope of work? Okay, so then consequences of the wrong policy. So agents and brokers can be held liable for breach of their professional duty to secure the insurance that you need. But there is an assumption that you as a contractor read and understood the policy that you bought. I mean, it's like any other contract. You read the terms and conditions, you do it knowingly, you do it with an intent to be bound. But it's best to avoid a legal fight if at all possible. So you're going to want to ask any questions in writing. Make sure, again, your broker knows the scope of work that you're performing. Save a written record of what you told them. Get a copy of your insurance application. If it doesn't say something or you have cause for concern, ask for that representation in writing. And if that broker refuses to provide it to you, should be cause for concern. And also, you might want to ask for a copy of their own professional liability insurance policy, because at the end of the day, that agent, if you're relying on that agent's representation, his policy may be the only policy that provides you with future coverage. And it honestly should make them uncomfortable, or they should feel confident about it and have no issue. Okay, so then talking about tendering the defense. So insurance companies have a duty to defend. The duty to defend is greater than the duty to indemnify. The duty to defend, which is in essence paying for your legal counsel to defend you in the action. The standard is the mere possibility of coverage. So California courts have emphasized that insurance companies have a duty to defend so long as there is the mere possibility or potential of coverage. Any doubt as to whether the facts give rise to a duty to defend is to be resolved in the insured's favor. So unsupported claims, evidence from any source, anything really, could be sort of that next piece to sort of just push it over the edge, and therefore an insurance company picks up the defense. The duty to indemnify is paying for that damage, right? So after the trial or the arbitration, what's awarded, that is the duty to indemnify. That is the insurance company picking up, the cost on those damages. And then the other thing to think about too is reservation of rights. Those reservation of rights letters, I've seen them very expansive and sort of all encompassing. And then I've seen them be very sort of, minimal in regards to what they're reserving their rights to. And largely what that means is we're going to give coverage, but we're reserving our rights to preclude coverage at a later date in the event that there's evidence, of something like an intentional act that would preclude coverage. If it's determined that, the individual, perpetrated fraud, and they may say, well, we're not going to cover it, right? So that's largely what the reservation of rights is. So just be aware, because it could come with a price tag on the back end. In regards to a case study back to the roofer, will the insurance carrier pay for defense if the complaint doesn't say if anything was damaged? Maybe, but remember, CGL policies look for bodily injury, property damages, specifically damages as a result of the occurrence. So it really just depends. Will the insurance pay for the other party's fees if you lose? No, not even if there's an attorney's fee provision. So why does tendering matter? It puts your insurance carrier on notice, and you're going to want to do that as soon as possible. So if someone comes in and says that, I have to submit a claim on my insurance, I'm being sued for negligence. Okay, I need a copy of your policy. And I look at the policy, I am going to tender ASAP. And I'm going to do that because the date of tender is the date that's going to trigger coverage, assuming that there is an occurrence that's covered. Because anything that's incurred in attorney's fees post-tender is going to be covered by the carrier. So do not delay in tendering to your carrier. And cases are often won or lost at that point, because depending on what your financial wherewithal is to defend a case, if you don't have the resources available, that insurance coverage is going to be absolutely necessary. So you need to tender ASAP. What about subcontractors? That's going to depend. It's going to depend on your insurance certificate. It's going to depend on there's an additional endorsement. So when you get those accord pages where it has like a summary of your aggregate limits, it should have an additional insured, whoever that may be. And also make sure that the language in your subcontract with subcontractors has language that basically requires them to have CGL policy, and get that information and ask for updated copies of that policy as evidence that they have coverage. Now, if I think I maybe went back, but if you have a pre-existing lawsuit, consult an attorney. If you're sued, make sure you send a copy of that complaint to the attorney. And always have an attorney who knows insurance review the complaint. And I say that because I've been on both sides of this. I've drafted complaints with the intent of precluding coverage as a strategy. And then also, being on the side of reviewing the complaint and saying, okay, yes, we should have coverage here, and submitting based off of that. So sometimes whether there's coverage is going to really depend on what is stated in the complaint. So you could be wrongfully denied a defense if the complaint is poorly drafted, and that is just an unfortunate circumstance. And unless counsel on the other side is willing to amend, which they may not, because knowing that they probably drafted that with the intent of you not having coverage, but it's possible you could get lucky. So it's important to review and have an attorney review it, because don't make an assumption that there is or there isn't. I would have someone look at it. Also, the other thing is, if there's a conflict, you may be entitled to choose your own attorney, which is Kuma's counsel, which is largely the insurance company pays for you to have separate counsel, because panel counsel, the go-to for that insurance carrier, maybe is conflicted based off of the parties that they're representing in the action. Okay, so that is the end. This is not considered an all-inclusive presentation, but sort of a high-level overview of the most pertinent parts of a CGL and what I want to make sure that everyone is aware of. Here is my contact information. Feel free to shoot me an email if you need help reviewing your policy. If you have questions, this is recorded, so we will make it available. But also, reach out to us if you need assistance. So does anyone have any questions? Because I have no questions in the chat right now. You can unmute or you can type in a question. And this is it's a very in-depth sort of topic. So please utilize this time. If you have a question about CGL policies, ask it. If I don't have any questions, then I'm going to just go ahead and conclude the presentation. But again, I want to thank everyone for your time. Hope this was helpful. Again, we'll make it available and feel free to reach out if you have any questions about CGL policies or about your CGL policy, or if you find yourself in a circumstance where a complaint's been filed and you have to submit a claim, feel free to reach out. Everyone have a good day. And again, I appreciate your time. Thanks.